For us to continue to give you this valuable content, please like, share, and subscribe. Welcome to the third video of Understanding the 1040 series. In this video we will be going over the third section of the 1040. Dependents. A qualifying child is a child who is your son, daughter, stepchild, foster child, brother, sister, stepbrother, stepsister, half-brother, half-sister, grandchild, niece, and/or nephew. A qualifying child is a child who has to be under age 19 at the end of the tax year and younger than you, or under age 24 at the end of the tax year who is a student and younger than you, or any age with a permanent and total disability. And the qualifying child cannot have provided over half of their own support for the tax year. And who lived with you for more than half of the tax year. And the qualifying child cannot file a joint return for that tax year, or is filing a joint return for that tax year, only to claim a refund of withheld income tax or estimated taxes paid. If so, they would be filing as a dependent of another. Is the qualifying child your dependent? A U.S. citizen, national, resident alien, resident of Canada or Mexico? Married? Could you, or your spouse if filing jointly, be claimed as a dependent on someone else's tax return for that tax year? Was the child under age 17, or under age 24 still in school at the end of the tax year? Did this child have a social security number, valid for employment issued before the due date of your tax return? Is your qualifying relative your dependent? A qualifying relative is a person who is your son, daughter, stepchild, foster child, or a descendant of any of them, for example, your grandchild. Or brother, sister, half-brother, half-sister, or a son or daughter of any of them, for example, your niece or nephew. Or father, mother, or an ancestor or sibling of either of them, for example, your grandmother, grandfather, aunt, or uncle. Or stepbrother, stepsister, stepfather, stepmother, son-in-law, daughter-in-law, father-in-law, mother-in-law, brother-in-law, or sister-in-law. Or any other person, other than your spouse, who lived with you all year, as a member of your household, if your relationship didn't violate local law. And isn't a qualifying child of any taxpayer for that tax year, which isn't required to file a return, or files only to get a refund of withheld income tax or estimated taxes paid, which is a dependent of another. And your qualifying relative had gross income of less than $4,400 in that tax year. And you provided over half of the qualifying relative support in that tax year. An adopted child is always treated as your own child. An adopted child includes a child lawfully placed with you for legal adoption. If you have a dependent who was placed with you for legal adoption, and you don't know the dependent's social security number, you must get an ATIN, using Form W-7. You will be using Form W-7A, if the dependent isn't a citizen. Children of divorced, or separated parents. A child will be treated as the qualifying child, or qualifying relative of the child's non-custodial parent if the parents are divorced, legally separated, separated under a written separation agreement, or lived apart at all times during the last 6 months of the tax year. A child will be treated as the qualifying child, or qualifying relative of the child's non-custodial parent if the child received over half of the child's support for the tax year from the parents. Support of a child received from a parent's spouse is treated as provided by the parent. A child will be treated as the qualifying child, or qualifying relative of the child's non-custodial parent if the child is in custody of one, or both of the parents for more than half of the tax year. The custodial parent signs Form 8332 stating they won't claim the child as a dependent for the tax year, and the non-custodial parent includes a copy of the form or statement with their return. Form 8332 will be covered in another video in detail. If all conditions apply, only the non-custodial parent can claim the child for purposes of the child tax credits and credit for other dependents. However, this doesn't allow the non-custodial parent to claim head of household filing status, the credit for child and dependent care expenses, the exclusion for dependent care benefits, or the earned income credit. The custodial parent or another taxpayer, if eligible, can claim the child for the earned income credit and these other benefits. The custodial parent is the parent with whom the child lived for the greater number of nights in that tax year. The non-custodial parent is the other parent. If the child was with each parent for an equal number of nights, the custodial parent is the parent with the higher adjusted gross income. The non-custodial parent can claim the child as a dependent without regard to any condition, such as payment of support, and the other parent won't claim the child as a dependent, and it's proven with a decree or agreement. A custodial parent who has revoked their previous release of a claim to certain tax benefits for a child must include a copy of the revocation with their return attaching Form 8332. If you are a U.S. citizen or U.S. national, and your adopted child lived with you all year as a member of your household, that child meets the requirement to be a U.S. citizen. If your relative is permanently and totally disabled, certain income for services performed at a sheltered workshop may be excluded for this test. Temporary absences by you or the other person for special circumstances, such as school, vacation, business, medical care, military service, or detention in a juvenile facility, count as time the person lived with you. An exemption to time lived with you includes if the person meets all other requirements to be your qualifying child, but was born or died within that year, lived with you for more than half the year, adopted or lawfully placed within that year as their main home. A foster child is any child placed with you by an authorized placement agency or by judgment, decree, or other order of any court of competent jurisdiction. If your child is presumed to have been kidnapped, you may be able to take the child into account in determining your eligibility for head of household or qualifying surviving spouse filing status, the child tax credit, the credit for other dependents, and the earned income credit, EIC. If the person is married and files a joint return, you can't claim that person as your dependent. However, if they file only to claim a refund of withheld income tax or estimated taxes paid, you may be able to claim that person as a dependent. If no one person contributed over half of the support of your relative or household member, but you and another person's provided more than half of their support, special rules may apply that would treat you as having provided over half of the support. A person is permanently and totally disabled if, at any time in that tax year, a doctor has determined that this condition has lasted, or can be expected to last continuously for at least a year, or can be expected to lead to death. If you received payments under the Temporary Assistance for Needy Families (TANF) program, or other public assistance program, and you used the money to support another person. Even if a child meets the conditions to be the qualifying child of more than one person, only one person can claim the child for the following tax benefits: earned income credit, child tax credit, and dependent care credit. If you and any other person can claim the child as a qualifying child, the following rules apply. For purposes of these rules, the term parent means a biological or adoptive parent of an individual. It doesn't include a step-parent or foster parent unless adopted. You live home with your parent, the head of household, whom assists financially for your child. The child meets the conditions to be a qualifying child for both you and your parent. The parent is head of household and has the highest AGI, is the taxpayer most qualified to claim the child. Your child must have the required, valid for employment, Social Security number. If your child was a U.S. citizen when you received it, it is valid. If not valid for employment is on the card, and your child's immigration status has changed, order a new card. If the child was born and died in that tax year, and you do not have a Social Security number for the child, enter died in column 2 of the Dependents section, and include a copy of the child's birth and death certificate or hospital records attached to a paper return. If you, or your spouse if filing jointly, didn't have a Social Security number, or ITIN, issued on, or before the due date of your tax return, you can't claim the child tax credit, or the credit for other dependents on your original, or an amended, for that year's tax return. A school includes college, a technical trade, or mechanical school. It does not include on-the-job training course, correspondence school, or school offering courses only through the Internet. A student is a child who during any part of 5 calendar months of that tax year was enrolled as a full-time student at a school, or took a full-time on-farm training course given by a school, or a state, county, or local government agency. This is the end of the third video of Understanding the 1040 series, the third section of the 1040, topic, Dependents. Go to the next video, section 4 of the 1040. For us to continue to give you this valuable content, please like, share, and subscribe.